Report one is now in session. The Honorable Chief Justice Robert J. Torres presiding.
Afide, good morning. You may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA24-009, People of Guam Plaintiff Appellant v. Joseph Kitsutu Taimanglo II, Defendant Appellee. Appearing for Plaintiff Appellant is Attorney Nathan M. Tennyson. Appearing for Defendant Appellee is Attorney Peter J. Santos. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Tennyson reserves 10 minutes.
Mr. Tennyson, you're in a different position today. You may proceed.
Chief Justice, may it please the court. We're here before this court today to discuss what the people allege was error in the trial court concerning the trial court's granting of a motion to suppress evidence. The question for this court today is there a reasonable expectation of privacy in a cell phone case that's been, when the cell phone has been misplaced on the side of a road or in a location where subject to public access? And the relevant facts for this court on this issue is there was a car chase. Defendant Taimanglo was driving, a rather long car chase ended near the naval base.
Excuse me, Mr. Tennyson. I
Yes.
thought he was a passenger.
He may have been a passenger, Your Honor. I apologize. He was in a vehicle
Okay.
subject to a high-speed chase. Thank you for that. The chase ended when the car collided with a utility pole, I believe. The driver was injured, I believe, on the side of the road. Mr. Taimanglo fled on foot. Some officers got there, found two cell phones on the side of the road in the grass, I believe. And as they were bringing Mr. Taimanglo back, he says, "Hey, that's my phone, the one with the brown case," as the officer peels the case off and finds meth.
Our standard of review is clear error, right? At least of the finding of fact that the property had not been abandoned.
Correct.
So how did the trial court commit error, clear error, when it found that it was at least as likely that he inadvertently lost his cell phone or, either during or immediately after the car crash, and that he did not intentionally abandon it?
Yes. So the people would not say that that was clear error. I think that is a reasonable conclusion. There's not enough evidence sufficient to determine, an abandonment of an ownership right in the phone. What the people contest is that the legal analysis was incorrect. This is less about personal ownership of the phone, having an ownership right, than it is to the reasonable expectation of privacy and property that's been set aside.
So what was the court used this standard from the Ninth Circuit that seemed to rely on in terms of determining whether property was abandoned. Are you suggesting that that standard is not the standard that they should have used?
I believe in the Ninth Circuit, I believe that the authority cited by the trial court was to the dissent. And I think the primary concern with that authority is the majority opinion had discussed more of a broader context, things really being kind of sensitive to the facts of the situation. And we had cited to some other cases, and particularly the Ninth Circuit also said in United States v. Wilson, and this is a quote I rather like because I think it gets to the heart of the issue. "It is more accurate to look at the purpose of the Fourth Amendment. Privacy rather than hereditaments has motivated the recent decisions. Cases like Jones and Katz encourage a functional approach to the Fourth Amendment. The objective is a protection of a justifiable expectation of privacy and freedom from governmental intrusion." And an example was set forth in Inri Baraka, where there was a minor, I believe, was on the side of the street on the curb. He had a bag, not exactly within his sphere of control, far enough that people would reasonably not know if it was his bag or not. And the police did search that bag, and it was found there was no reasonable expectation of privacy. And I think in this case, let's say that Mr. Taimanglo had been able to retain his phone, or he'd stayed at the scene looking for his phone. There becomes a heightened expectation of privacy and something like that. Had
Well,
he had-
that's assuming that he knew that his phone was lost. And, you know, to me, in terms of the standard that the trial court applied, in terms of whether or not the property was abandoned, it goes to intent and the physical relinquishment of the property. I mean, you go back and you provide context in terms of reasonable expectation of privacy, but what does that mean in this context? If someone intentionally gives up their phone and both physically and that was their purpose, then the abandonment is more or less defined. But if someone just loses their phone, that to me is a little different in terms of what does it mean, whether or not that person still maintains a reasonable expectation of privacy. And I think it makes a difference with abandonment and loss property. You seem to suggest, at least from the briefs that I can recall, that whether it's abandoned or lost, it's the same standard.
And I think where it really does hinge on is, you know, I think we all appreciate that we lose something, we don't realize we lost it. We don't want people necessarily looking through it. An example I provided, I didn't bring any props with me, but I had thought about leaving a backpack in the back seats. You know, it is mine, but if I forget my bag, I leave it in a public place. What's my expectation of privacy in the bag? In the sense of someone coming along, finding it, saying, well, whose bag is this? What's the first thing we do? You know, I mean, do they turn it over to the police? And then the police have to get a warrant to do a basic search to see, well, is there an ID, for example, in a wallet, to open it up, see, is there any identification?
Yeah, but I mean, lost and mislaid property, I think still remains protected by the Fourth Amendment. It seems like the standards are examining like what would be the least intrusive means of trying to identify the owner. And in that case, if you had a tag on it that said Nathan Tennyson, then, you know, for me to open up the bag and start to sift through it saying I'm trying to find an owner, I don't think that would be reasonable.
No, I agree with you on that, Your Honor. There is a minimally invasive way of getting around to doing that kind of a thing. So if the tag outside says my name, search is done. If it doesn't, and you know, with a bag, there's a lot of options with a bag of where to look. Let's say it's more something easier like a wallet or a coat, something where there's a pocket, maybe it has a name, a card, something. And in the case of the cell phone, I don't keep a cover on my phone. I don't store anything with my phone. Some people do. And what we're advocating for is nowhere near the, oh, you know, let's crack the phone, let's open it, look inside the data contents. That is too far. But, and there is some precedent out of California saying that even to look at the
Identifying
serial number, I mean, and that's even more invasive than what was done in this case of just because then you need to actually take the physical back off the phone, remove the battery in some cases to find the serial number. And that's a more extreme search. That's something we know we have no clear basis. I mean, the concern I have here is the location of the phones relative to the crashed vehicle. There is some kind of causal relation between them, but it's not enough to make an inference, a reasonable inference, that they're related to the vehicle. I can imagine a scenario where a car prior to that drove by, windows down, kids in the back, grabs their parents' cell phones and throws them out, and the parents don't know, and they're on the grass. A pedestrian walks by, drops them. Any other way they could have gotten there, you know, it comes down to once they are found by someone who doesn't know.
But what about, you know, the Taimanglo's acknowledgement or admission that the cell phone was his? I know you say, well, we're not so sure we can believe him, but I mean, he's already made that assertion.
Mm-hmm.
You have the connection to the accident. You know, at the time he was questioned, even at the precinct, he reaffirmed his ownership in the thing, even after you know, they had found it. So
Yes. And that,
And the court viewed that as being important when it
Mhm.
made its decision of that there wasn't an intentional abandonment.
mhm. And I think for our argument, I think that's the trickiest fact to deal with. And even, I mean, I take what's in the record, but I mean, the testimony I think was these were simultaneous things that happened. You know, I'm not sure what the order of the events was. Was it Mr. Taimanglo said, "Hey, that's my phone," and then it was opened? Was it being opened and he said, "That's my phone"? Was it really simultaneous? To address that, the people's argument is basically that it doesn't really matter. You know, his statement that it's his phone, I think a finder would give it some weight, but also if I was to find two phones like that and someone just said, "Hey, that one's my phone," I would want a little more information. Okay, what's the image on the screen? If I, you know, can you tell me something else that you can't apparently see that I can use to identify that it is you? You know, phones can be expensive. The information on them can be valuable as well. You know,
And couldn't the officer have done that? Oh, just touch the screen and say, what's your screensaver?
that's what pops, that's
What, you know, what's your, or look and see if the name was right on the phone.
that's
I
a
mean-
possibility, Your Honor. And I think that's also subject to the timing of how things happened. If it had been stated earlier it was my phone, maybe that would have been an approach. Maybe the officer still would have removed the case. I'm not sure. And I mean, really I think the point we would make is there is a difference between Mr. Taimanglo's propertyship right or ownership right in the phone relative to the expectation of privacy. The expectation of privacy is from an objective context situation of, is this item left in a place where I can identify this zone of control? Can I identify the owner? Do I know who to whom it belongs? You know, if Mr. Taimanglo had kept the phone on him and it had been taken from the police after from his person and then opened, I think there's a problem. I think the reason why it shouldn't have been suppressed in this instance is because it was left in an open public place and there was no definitive way of determining it was Mr. Taimanglo's outside of his word. And the least minimal way, it's really two, is one, if it's your phone, unlock it. And
I mean, I can appreciate the concern and in terms of your expression in reference to not just turning over the phone, just because he said it's my phone, I'm going to turn it over to you, and that's the end of it. But you know, the facts of the case and the circumstances is that the police officers were pursuing a speeding vehicle. It ended up in a crash. The passenger fled and was seemingly trying to get away from the police. Now, they found a phone on a public place next to the vehicle. Number one, they, you know, before they can proceed to search that phone, they could get a warrant. Or number two is that if this person is fleeing the scene of an accident, he could have been placed under arrest. And then that would have provided the police officer an exception to then search that phone in terms of it, you know, search incident to an arrest. So it's not like there were no options or exceptions other than just turning over the phone. There are recognized processes that I think the police officers properly trained could have pursued.
And that is possible, Your Honor. I would say to the warrant issue, that is always an option. I would be cautious in the sense of if the court were to uphold the trial court and say, yeah, this is something you should have gotten a warrant for. I think there would be a chilling effect in the sense of, well, what else of this nature might require?
Well, you
a
argue
warrant?
that it's a valid inventory search. And, you know, in order for you to, in order for the police officers to conduct an inventory search down in the police station, my understanding of the case law is there must be a valid arrest. without an arrest. I don't read the cases to say that then they can do an inventory search.
Mhm.
So again, there is a means in which this can be validly accomplished, short of a warrant. If you say that that's going to be too burdensome, they're out in the field, that's not realistic. Okay, that's why you have the exceptions to the warrant requirement. And in this particular case, your argument is that the property was abandoned. Therefore, the Fourth Amendment does imply there's no reasonable expectation of privacy. Oh, that's fact intensive, and that there are questions in my mind as to whether or not that phone was abandoned. As the trial court said, it was just as equally possible that the phone was lost when he was fleeing the scene of the accident.
Yes, and I'm not of the opinion that the phone was abandoned. I'm not arguing that the property interest was abandoned. I'm differentiating the property interest from an expectation of privacy I might have to something that has, even if unintentionally, been mislaid in a public area. Because if someone comes upon it, they're not going to look at it and say, oh, this was clearly unintentionally lost by someone, or, oh, this was intentionally abandoned. That is a very intensive need to look into the inner state of the person who did the abandoning or the losing, or and that entire process can be avoided if we're looking at this less from a property and ownership perspective and more of a, where was it located? You know, if it had been inside of his home, reasonable expectation of privacy. Lost on the side of a road, even with the proximity to the accident, much larger question of what's the reasonable expectation of privacy. And even and this is more of a minor point in terms of lost property, because as indicated, there's ways of determining if it's Mr. Taimanglo's phone or if it was phones that had been stolen or someone else's phone or any scenario that could have arisen. Is that even under the lost property statutes, the officers at a point do have the access and the ability to be where the meth was found in the back of the cell phone case to find identifying information.
There was no argument downstairs though, or, at the trial court that the property was lost, right? I mean, I think the focus was, there were two things. It was abandoned or it was an inventory search. I know you weren't there.
Yeah.
But the trial court never addressed that issue at all.
Yes, and I think the issue with the inventory search argument, I think that was eventually dropped. Is inventory search is usually done after the arrest, as Justice Carbolito has indicated. There had been no arrest at that point. We're not inventorying possessions at that time. And this is what leads to the, and I don't believe Guam has adopted the inevitable discovery doctrine. And I would suggest in this case, they consider on the basis that if there was a better practice for the officers to use, that is something that can be set forth. And had they instituted that at the time, let's say, okay, unlock the phone. Okay, it's yours. I'll give it back to you, Mr. Taimanglo. He was arrested. And I think he probably would have been arrested even without the meth due to the incident.
High-speed chase, yeah. But I mean, and I don't think, any of us, that was Justice Carbolito pointed out, there seemed to be a basis to go forward and make the arrest even before doing the search of the phone. The problem I have as well with the inevitable discovery is, again, that wasn't addressed by the trial court below, and we're raising it for the first time on appeal.
Mm-hmm.
That even if the evidence was the fruit of an illegal search, it would have inevitably been discovered later during a proper inventory search.
Yes, and there is that issue below as the argument was made as to the inventory search, but there was no causal link bringing in the inevitable discovery into that.
But even if we were to address it on appeal for the first time on appeal, the argument, as I understand, of an inevitable discovery is that had they done an inventory at the police station, it would have been discovered eventually. but then you are basing that on a proper inventory search. And as you've conceded, there was no arrest. And before you can have an inventory search, there must be an arrest. And so the testimony was there was no arrest. There was no then proper inventory, or there could not have been a proper inventory search. And so the inevitable discovery goes by the wayside because there's a step that is necessary in order for it to be inevitably discovered could not have been properly taken or was not properly taken.
And my recollection or understanding is he had been arrested. If I'm incorrect on that, then that does cut against the inevitable discovery doctrine. However, if there was an arrest, and I don't have the record available to me immediately to double check, it would have been found in that process. But that's really a fallback argument. I would just lead back into our primary position, which is this is something that should be analyzed through objective analysis of someone from the outside looking in without getting into the internal mindset of, well, you know, is it my property? Did I intentionally lose it? Was it an accident? The fact of the matter is, at the end of the day, if something's left in a public space, it has a diminished expectation of privacy. That's not an abrogation of the full expectation of privacy, as we discussed. That doesn't authorize you to then go crack the phone, look into it, go through the personal stuff. But it does raise.
I think you raise a valid point. Had the facts of the case been different, I think in this particular case, in my mind, the fact that you advance that it was in a public place, and that, but you know, it occurred right after an accident. Someone was fleeing, and as the trial court very rationally advanced, it could very well have been that he lost the phone.
Mm-hmm.
And there are different standards that apply from when someone abandons a phone as opposed to someone who loses something, as you know, you've indicated, and therefore the reasonable expectation of privacy has a different application. And so it's not, I mean, the facts that we're dealt with here is that as an equally proper explanation that phone could have been lost, and therefore the reasonable expectation of privacy is not given up.
So I agree with the first part regarding the factual assessment. I do differ on the legal conclusion, and that's.
Yeah, but you
fine.
haven't cited any case that we should treat abandoned and lost, or not, I guess, I don't know. It has not come to my attention that abandoned and lost property for Fourth Amendment purposes should be treated the same way.
I think there is, and I can actually raise this on my rebuttal. I can look through my brief. I think I may have a case on that, Your Honor.
That's not the Ninth Circuit law, though.
I need to double check, Your Honor. And if I may, I'll stop at this point and allow.
Let me just ask two other questions. First, with regards to the inevitable discovery argument. My understanding is that the doctrine requires that the discovery, the fact that makes the discovery inevitable has to be different from the circumstances from the legal search. Mm-hmm. So in this case, if the idea was that he was going to be charged for only for drug possession, which was all he was charged for, mm-hmm. and the evidence that was seized were the drugs on the phone. If he was arrested for fleeing the accident, and then they said, well, he was arrested for fleeing and he was charged, then, potentially, I think if we ever reach the merits, the evidence might have been able to come in under the inevitable discovery, assuming that we say, okay, we're going to hear it on the first time on appeal. But how do we get over that hurdle when it looks like the only charge that he was charged with was drug possession, and that is not different, that arise from the circumstances of the arguably illegal search?
Yes, Your Honor. I think that the problem there is really, and I don't have access to what the discussion was when they were charging and looking at it, or even what the police were. I mean, clearly the arrest was based on the finding of the meth. That's what kind of derailed what might have happened. And I think it's difficult to go back in time now and say, well, if they hadn't have found the meth, there would have been lesser charges that weren't the drug possession. There would have been, fleeing from the scene.
They could have charged both and still got the meth in on potentially under the inevitable discovery.
And they did, and that's the thing is, up until the meth was found, they didn't know that the meth was there. But it changed the trajectory of things. And I mean, after this, depending on the outcome of this case, if the police were to have guidance on the proper procedure for handling that kind of a scenario, similar issues could be avoided in the future. But I think it's just uncertainty as to what would have happened. We can't go back and determine that. And I'm unaware of what determination the prosecution would have made in, bringing up those additional charges when they had the meth.
Fleeing the scene of an accident would have been pretty easy. Let me ask the other question that I had, and that was the trial court wasn't clear about the whether abandonment had to be proved by clear and convincing evidence or by a preponderance, and it said under either standard it was met here. Do you have a thought as to whether it should be clear and convincing or preponderance in terms of determining whether abandonment has been proven?
I would say my initial thought, without doing any research or thinking about it, would be preponderance of the evidence. I think it would be a slightly lessened standard just because there is we can't know the inner workings of the mind of the person without them speaking. And even then it can be a little suspect. I think it's an analysis of what a reasonable person would have perceived in response to those facts. And I think that's worthy of a preponderance rather than clear and convincing evidence. That would be my initial position.
All right, thank you. Any further questions for Mr. Tennyson? Mr. Santos?
Thank you.
You'll have 3.5 minutes, Mr. Tennyson.
Mr. Chief Justice Torres, Associate Justice Merriman, Associate Justice Carbolito, buenas and half a day. Pwede yun inamago fikoti. The government is trying to shove a square peg in a round hole. The cases that they have cited are very dissimilar to the facts and context of this case. What we have is the government trying to come up with a creative solution. That's a nice way of saying they're trying to use subterfuge or false pretense to commit government overreach. The Fourth Amendment.
The government argues that instead of looking at the ownership interest in the cell phone, they should have looked at his reasonable expectation of privacy when it's lost or abandoned in a public right of way. And there's a distinction between the ownership interest and the expectation of privacy. And the focus should be, what is the expectation of privacy that he has when that phone is lost or abandoned?
I don't believe that, I don't concede that the phone was abandoned, but as soon as Mr. Taimanglo said, that's my phone, full stop, then we don't use an analysis of whether it was abandoned or mislaid. It's now, we know who the ownership is, who has the ownership interest. And then that's when you have to use the proper procedures, as the court has been alluding to get around that. And so what I'm saying is, the Fourth Amendment right against unlawful search and seizure is the most litigated constitutional right, because we're trying to balance between a person's right to be secure in their person's houses, papers, and effects against unreasonable searches and seizures. Normally, a warrant is required for law enforcement to conduct a search. There are exceptions to the warrant, such as consent or exigent circumstances, which might apply in this case. But plain view and other exceptions, the inventory search, I disagree that that would apply. But they could have just asked them, okay, this is your phone. You mind if I look? They didn't. All right. Exigent circumstances. I don't think they would have thought a shotgun was behind the, to try to find and make sure there's no deadly weapons on the phone. So none of that happened here. And so now let's turn the attention to the inventory, the so-called inventory search, right? So the police do inventory searches, as has already been discussed, pursuant to a lawful arrest or even an unlawful arrest, but they still do an inventory search, right? They may also do not an inventory search, but do an inventory for property that's been found, lost, or mislaid. But again, the difference between the two is going to be how intrusive that they go and for what purpose, right? Is it for safekeeping? Is it for
Let's
looking for
focus,
evidence?
Mr. Santos, on what the trial court, the issue with the trial court. So, I mean, the trial court rejected the inventory search, as I read the record, because the number one, the prosecution did not produce the policy that could assure the trial court that there were proper standards that applied in protecting the Fourth Amendment rights of an individual. And so, but there was testimony. There was testimony on the part of the police officers on what that policy was and, what standards. So what was the issue? I mean, what was the shortcoming in reference to the description of the police officers in short of producing a written standard that why there were not proper assurances that there was this policy, it was in existence, it was followed, and there were proper protections. What was the shortcoming?
Well, one of the shortcomings could be if there's no written policy or if a policy doesn't exist, then it's up to each officer to decide what's proper and
Well,
what's not
I don't
proper.
know necessarily the testimony was that there was no written policy. My recollection is just it wasn't produced in court.
Yes.
But
So then there's no way for the trial court to look at the policy and see what the officer did and determine whether or not the officer performed in conformance with the policy.
well, so that's my question. What is it that what was the inquiry that was not satisfied as to why the testimony that there was this policy, these were the restriction standards, and that it was followed? Why was that not sufficient?
Again, like I stated, Your Honor, if the court doesn't have it, then they can't use it to determine whether or not the search was performed properly.
Well, if you look at the decision and order, I mean, we recognize that no written version of the policy was presented to the court. But if you look at the decision, it says no written version of the policy was presented to the court. And the testimony suggested that the policy is extremely broad in scope. And then it has a citation to a footnote that isn't in the decision and order. So we're trying to understand, how was the policy broad in scope? What was the, as Justice Carbolito's trying to allude to, why was it deficient in terms of not satisfying an inventory search exception to the Fourth Amendment?
I think that's a discretion that the court exercised. It could have decided the other way, that the testimony of the officer about an existence of a policy or the traditional practices of the police department, he could have said, okay, you guys are the police, you guys investigate, you guys confiscate things all the time, you should know what you're doing.
But
That could have
in
satisfied
Mr.
the question.
Sanchez, in my mind, what I'm trying to satisfy is, was there a proper basis for the trial court to reject the description of what that policy was and make the remark, it's too broad, there aren't sufficient standards and protections to conduct a proper inventory that protects the personal, that protects the privacy rights of an individual. If you just say it's too broad, I mean, I'm trying to understand what's the basis of that. And so I can then say, okay, I think the trial court was right, or no, I
Well,
don't think so.
I believe he was just concerned that there should be standards and policies in place and that we shouldn't just have police officers making up their own or deciding for themselves what is correct or incorrect. You know, they want to prevent the wild, wild west. You know, they don't want jungle rules to govern the police department. The police department is a paramilitary institution that has standards and they have to follow statutes and case law. And you can't, that doesn't, you know, it doesn't lend to having police officers just going out there and doing whatever.
Mr. Sanchez, what you're saying makes perfect sense. But what I'm trying to find out is what's the articulation that led the trial court to conclude that those standards that were described were too broad.
Probably, Your Honor, the testimony of the officers, they didn't go into very great specifics. They didn't, you know, there was no testimony elicited about any training programs that the department has or, you know, what.
What you're speculating, right?
Yes. Well, that's what I'm basically saying is there was nothing in the record to, I guess, there was nothing developed in the record to give the court comfort to say that, yeah, they have a policy that can be relied upon.
So
And it was the prosecution's burden to show the court, look, we're following certain rules and procedures and policies, and we should be okay here. So just saying that, oh, you know, we follow rules and we have a way of doing things, that shouldn't satisfy a court that they have a set policy and standards and guidelines when it comes to processing of evidence and crime scenes like that. So my next point, you know, about
Well, I'm just looking at the testimony and the officer said that the policy was to, you know, essentially conduct an inventory, confiscate it as evidence if it's related to an active crime scene. And that was the policy, you know, at least is how he was describing it. What's wrong with that policy?
well, it is broad. There's no context. I have seen policies where, you know, if we're looking at certain types of evidence, how it is supposed to be treated. If it's a weapon, if it's drugs, if it's you know, suspected I guess documentation or whatever. There's certain chain of custody issues that come into play, so on and so forth. And a very robust policy would have, you know, those different guidelines on how to treat certain things. And for them to just say, well, when there's evidence, we confiscate it and we put a custody receipt on it. That is a little bit too broad.
So you're saying that the policy that says, because this is what he says, if a crime has been committed, we'll conduct an inventory search, whether it's to confiscate evidence or to confiscate personal property for safekeeping. And you think that's too broad?
Yes,
Why?
because it's very, very, again, there are ways to handle certain types of evidence. That is a broad description, a general description of what gets done in a police investigation. But in as far as depending on the type of crime that's suspected, the type of evidence that's being handled, there's a lot more guidelines that should be in place. If it's perishable evidence, if it's dangerous evidence, if it's you know, evidence of a sex crime, so on and so forth. But I wanted, Your Honor, to point out the fact that there was no basis to arrest Mr. Taimanglo. as a passenger of a vehicle if he flees the scene. There was a crash, there was a high-speed chase. He was a passenger. He has committed no crimes. In essence, he is a potential victim or a witness.
Why did he flee?
He may have many different reasons why he fled. He could have been on house arrest. He could have been, on curfew. He wasn't supposed to be out. Whatever the case may be, the investigation didn't yield that. But based on what the investigation did yield is that he was a passenger in a high-speed chase that crashed. And again, from that set of facts, without digging any further, the only potential he is a victim of the crash if he got injured or a witness. And there's no requirement for a witness to stick around and talk to the police. There's no requirement for any citizen to report crime unless you're a doctor or a teacher that is a mandatory reporter. But a regular Joe, his name happens to be Joe in this case, has no legal requirement to report any crime that he is aware of or that he sees, unless he's a mandatory reporter. So there was no basis to arrest Mr. Taimanglo other than the meth that was found in the case, which leads me to my next point. The reason why I say subterfuge and false pretenses is because police have a standard line in their police reports when they make drug arrests. Based on my training and experience, users and dealers hide drugs in the back of their phone cases. So let's call it what it is. He was searching for drugs. He was searching for drugs. That's what it was. All the other, exercise in mental gymnastics that we went through about it being abandoned, about, whether it's an inventory search. Really, what it boils down to is this officer knew that didn't have reasonable or probable cause yet, but he had reasonable suspicion to believe that something was afoot. And so he was searching for drugs. That's basically what it is.
So,
was searching for drugs.
if the circumstances you're describing it was that Mr. Taimanglo, who fled the scene, threw the phone out and
I didn't say
relinquished the property, and you're saying that the police officers, let's call it what it is, was searching for drugs. But if he had abandoned his phone, would that have been protected by the Fourth Amendment?
If he had abandoned?
Yeah.
Oh, yeah. I never conceded that he had abandoned the phone or that he threw it out.
But you just went from point A to point B, and
I said in my brief, imagine that for a moment, and we're not conceding that, but even imagine that for a moment. As soon as he said, "That's my phone," then the game changes, the rules change. He has that expectation of privacy. And the argument that, well, it was in a public place and, could have been anybody's, not in this context, not really. There was a high-speed chase. It was a relatively remote area, not highly trafficked. Could someone have been passing by earlier and threw out a phone? Possibly, likely, not. But under the circumstances and in the context of this case, and most people know their phone when they see it, right? They're with it 24/7. They know their phone. I could have 7 phones on the table here and my phone, and I will point to you every single time which one is my phone. And so the argument that, well, we had to verify the ID, it's not really a strong argument. When someone sees their phone, that's their phone. They know.
But if, I mean, let's talk about context in reference to a police officer trying to do their job. And so you just say, "That's my phone." So you expect the officer says, "Okay, here it is, take it." Or would it be unreasonable for the police officer to then try and inquire whether or not that person who just fled the scene of an accident is telling the truth? What is there to hide? I mean, if if the police officer wants some proof that that is his phone, do you think that's unreasonable?
No, but
What
what he
you
did,
just said, if he says that's my phone, just turn it over to him, give it to him.
right, as was discussed earlier, he could have, activated the screensaver. If it's locked, say here, unlock the phone. There are other options he could have had. But going straight to opening the case, the testimony, as I recall it, is that when he walked up, he had one of the corners partially removed. And then that's when he says, that's my phone. And then that's when everything should have stopped. Then instead of saying, prove to me it's your phone, is this your, or, if it's locked, then unlock it, so on and so forth. He immediately proceeds to peel open the case. Not everybody writes their name on the back of the phone. There could have been a ID card back there, sure. But what really is happening, Your Honors, is that he's looking for evidence of crime. That's really what this is. And it is a clear cut, in our view, violation of the Fourth Amendment. He should not, there were other ways around this, even if it was kept for safekeeping. But the next part I wanted to talk about is, the same argument that the police have a right or a duty to identify, the owner of the phone. Well, the cases that the people had cited where it involved a cell phone is so very different from the context here. Finding a cell phone in a pharmacy that was robbed and left there for 30 minutes and the police officers didn't open it until about a week later. Finding a cell phone next to a dead body and we don't know who the owner is. Totally different from this case. We have the owner there present and says, that's my phone. And so if we're gonna stand for the proposition that even though someone says that's my phone or that's my bag, right? Well, wait a minute, I need to make sure, the government can't have it both ways. In a lot of cases, they say that, there's no identification for this found in this bag, but when they open it, it was meth and it was within close proximity and control of this individual. So therefore it must be his. So and he's denying ownership. And so they're arguing, no, it is yours because it was right there. Now they're saying, well, just because it was close to you or is close to the crash, there's no way of me knowing it was yours. So you can't, have an argument only when it suits you. You have to be consistent. And so I think it's plainly obvious that there is a Fourth Amendment violation in this case. I think I just want to reiterate the fact that the inevitable discovery, there couldn't have been because there was no basis for an arrest. We don't know whether he was under house arrest or curfew or whatever that he was violating that he could have been arrested for. But the plain facts from the record is that he fled a crash scene where he was the passenger and he had no legal duty to be a witness. He was a potential victim, but there was no crime that he committed at that point in time. The only reason he was arrested was because of the methamphetamine that was found in the back of his cell phone, which was discovered as a result of a illegal search. The court below took the evidence, took the testimony, reasoned that it was a bad inventory search. I disagree with the fact that it was an inventory search, and I disagree with the reason the court came to that conclusion. I disagree because our contention is that as soon as he said, that's my phone, then the full panoply of Fourth Amendment protections comes into play. And the officer did not ask for consent. There was no exigent circumstance. It wasn't in plain view, and he didn't get a warrant. So therefore, it's a bad search. And the court should uphold the finding of the lower court, but on that basis. Thank you.
Thank you, Mr. Santos. Mr. Tennyson, 3.5 minutes in rebuttal.
Thank you. Two quick items I'd like to cover. You know, I can unlock my wife's phone. I know her wallpaper, but it's not my phone. So even to say, well, he could unlock it, wallpaper, as I've thought about it, is it an indica of ownership? Yes. Is it proof positive? No. And I won't dispute that in a way, people here today are arguing for, in a way, an expansion of police power. But it's not through mental gymnastics or poor thought. We're really arguing for a functional Fourth Amendment involving expectation of privacy. And what really comes to my mind is, so there's two potential different scenarios for this phone. It was abandoned or it was lost. If it was abandoned, there's no expectation of privacy. If it's lost, there's an expectation of privacy. Those are both based on subjective internal world of the person who lost or abandoned the phone. And by separating them, you need to have additional information in order for the police to determine, well, is there a reasonable expectation of privacy or not? I guess we need to ask them, did you intend to abandon your ownership or did you just merely lose it? I mean, the standard case we think of is, police are chasing someone with a bag. In the rush, he throws the bag out to the side, discards it in the dark, and the police find it. What's to prevent this person from, after the fact, saying, "Oh, in the rush of it, this was really a dear bag to me, and in this rush of fleeing, I didn't realize I had dropped it. I lost it."
But Mr. Tennyson, the significant point that Mr. Santos makes is that Mr. Taimanglo said, "That's my phone."
Yes, and for that is an indicator of ownership, but also, and I will just I'm just going to respond to that, just point to the statutes on lost property. If it's lost, then these apply.
But again, that wasn't the argument below, was
No.
that he had lost it, right? That's being raised here. The argument below was it was abandoned or it was an inventory search.
And I would say, I think abandoned in that sense, I will continue to argue that abandonment means expectation of privacy, not ownership, because I think they need to be decoupled. I think if we have this subjective tether, I think it makes things more complicated. It makes it harder to enforce and to have an expectation of how things will proceed.
If you say that's my phone, don't you then have a reasonable expectation of privacy? So that the government takes the phone in order to have access to whatever the contents are, it has to get a warrant. Isn't that
So-
straight up simple law?
And to that point, I would say it depends on the context of where the phone was found. If we're in here and it's on a table and I say that's my phone, I think there's a little more to it than fled the scene. There's two phones. That one is mine. I think, as I said, there is an indica there, but I think more is required. And if I may just finish this thought, and even under the property statutes, the finder takes on duties as a depository, and they can seek, in good faith, they can seek reasonable proof of ownership. I think that's more than just a statement of ownership. That's part of it. But with that, thank you.
Thank you, Mr. Tennyson. Thank you, Mr. Santos. The court will take the matter in advice.